fourth block. Today's class, fourth block about company meetings we are going to discuss. So at the end of this subject, you will be able to understand what are the various types of meetings of a company, and you also focus upon the requisites to conduct a meeting, like what are the important prerequisites to conduct a meeting, like notice, agenda, minutes. And also you'll be able to define what is meeting and its purpose, identify different types of meetings, and resolutions. Okay, so in today's class we are going to discuss about prerequisites of meetings meaning, and types of meetings. Yes, as I mentioned, a company as an artificial person created by the law cannot perform its functions on its own. So directors act as an agents on behalf of company and undertake the functioning of stock companies. So at the same time, these directors, the decision making, any decisions cannot be taken individually on their own. So any decisions relating to the company has to be taken collectively by the board of directors. So the decision making powers of a company are vested in the hands of members and board of directors. So such powers are exercised through meetings of members, and any decision we can exercise only with the meetings of members, but not individually. Okay. Right. So in company, meetings are held under the company's protocol. Okay, whatever the company protocol is there, as per the company protocol only, they are supposed to conduct the meeting. Procedures, protocol and procedures are there. As per that protocol and procedure given by the Companies Act are supposed to be conducted. Yes. What are those protocols required to be followed? So as I said, first let us see, before we get into the procedure for conducting the meeting, what is a meeting means. A meeting generally means what, when a group of people gather together and discuss about something, we generally, there is a meeting going on, right? So meeting plays an important role for the functioning of a company, because any decisions are taken by the board of directors, can be taken by the board of directors only through the meeting, because here meeting is the one where they discuss. This meeting provides a platform to the shareholders and the members of company to put forward the issues relating to the company and discuss the things, and based on the opinions expressed by different members and shareholders, a decision can be taken. Okay, so based on the opinions expressed by different members and the shareholders, decision can be taken. So meeting must be constituted by minimum 2 persons at least, under exceptional process. Like if it is a one-man company, one-person company, only one person can be the meeting, can conduct himself the meeting, means he himself takes. Except that one-person company, any other companies, the meeting must be conducted by the required number of directors and members. Okay, so every meeting conducted by company must be recorded properly, and every meeting have to be registered before the registrar of companies within 30 days. Okay, whatever meeting takes place in the company, that meeting related information has to be recorded in writing. Next, and that in the gist of the meeting, whatever is there, has to be registered with the register of companies within the 30 days of the meeting. So, generally, a company conducts the meetings annually once. Okay, companies conducts the meetings annually once in order to discuss the various business affairs of the company, apart from its other meetings. Like annual meetings are normal, a regular procedure. In order to discuss the business affairs and the decisions to be taken relating to the business. Apart from this annual general meeting, a company can also conduct other meetings depending on the situation, requirements, circumstances required, like extraordinary meeting and all. Okay. Yes. Before meeting, prerequisites of a meeting. Before conducting the meeting, the members who are responsible has to, and then who is responsible to conduct the meeting? In previous class we discussed. Can anyone? Who is responsible to conduct the meeting? Secretary. Okay. Secretary is the company secretary, is the person who is responsible to conduct the meeting, convey the meeting, and make arrangements for the meeting. In previous class we discussed. So before meeting, a notice of meeting has to be prepared, and an explanatory statement as per the section 1 or 2 has to be prepared. And during the meeting, it is responsibility to see quorum for meeting is being formed and chairman of meeting has attended, and if any proxies are there, or proxies, and conducting in order to take any decisions, voting, conducting voting method, and or resolutions. These all are the requisites. Like if any important decisions to be taken, then resolution will be passed. About these terms, we are going to discuss in our forthcoming topic, slides. Okay, and after the meeting, once the meeting gets over, this person has to prepare a minutes of meeting. It's a record. Minutes of meeting is a record which consists of the gist of the meeting. And he also must see that the meeting related, any decisions or votings are conducted, any decisions have been taken relating to that, maintenance and inspection of the documents that are passed in the meeting, are issued in the meeting, maintenance and inspection of these documents is also important. So prerequisites before meeting, during meeting, after meeting. Apart from this, we have some other things. Yes. One is proper convening authority. What is proper convening authority? That in order to conduct the meeting, there should be some people to take the decisions, right? So meetings can be conducted only by the board of directors, not individually. No individual directors, sorry, individual directors cannot take any decision, and if they take also, they are not valid. So any decision relating to the company matters are to be taken by the board of directors. So who are the convening authority to conduct the meeting? Board of directors, or in certain cases, if required, a company law tribunal or central government. Okay, national company law tribunal or central government takes the conducts the meeting. The second prerequisite of meeting is notice, as per section 101. What is notice? Notice is a statement which consists of the information about the meeting, which consists of the information about explanatory statement, which consists about the meeting. If this notice must contain these details like duration, how long a meeting is going to be, the time of the meeting, and where the meeting is going to be conducted, the day and date of the meeting. So must be given. So in the notice, what information is they are going to provide regarding what business matters they are going to discuss in the meeting, and then when the meeting is conducting, the date and day, time, where, the location. Okay, these details are to be provided in the notice. After that, subject matter to send. That is what the business matters to be discussed in the meeting, and who all the meeting notice has been sent, to whom the notice has to be sent. That is CEO and mode of notice. How this notice has to be given. Did you or any of you have find these notices? See, if you are working in offices, in office, you may receive a notice from your boss, right? He will, today we have a meeting in our conference hall at 2 to 4. And then if you are and who are all supposed to attend the meeting, right? And regarding what, right? And so how do you get the notice? You may get the notice as a circular among your like circular, okay, or you may get the notice as an advertisement, or you may get a notice through your mails, right? Right, right. So in notice, when someone says today we are going to have a meeting, what all you expect? You want to know today means there is a meeting means regarding what? Regarding what the meeting is going to be. First, that is subject matter. Second, when, date and time. Where, place, right? So these are, and who are all going to attend? Next, last question is who are all going to attend the meeting? So this information itself only provided in the notice and will be sent to all the relevant people concerned. And now the question is that it is to also to be think upon how the notice has to be sent. Depending on the gap that the notice has. Okay, time from the date of notice to the date of meeting, depending on the gap, and the importance of the notice meeting, company will send the notice to the members personally by post, or sometimes it may also give the notice by advertisement. You may used to find banks giving a notice. This is for the public notice. Okay, so do watch newspaper reading, do watch habit of reading newspapers. You'll find bank notice. This is so here and there. Okay, so a notice, mode of notice also important. The next, agenda. What is an agenda? Section 1 or 2 of Companies Act says agenda means a statement which consists about the business to be transacted at the meeting. Means upon what topics a business is going to be discussed. Okay, agenda. So to the notice, if agenda has so many points to discuss, if the meeting has so many points to discuss, so in this agenda, so many points are there, will be attached. Okay, a notice will attach with the enclosed with the agenda. So agenda means what? A statement of business to be transacted at the meeting. Agenda is a statement of business to be transacted at the meeting. Okay. The next, forum. Yes, to conduct a meeting, a quorum is required. Quorum means what? Minimum number of directors. Minimum number of directors to attend and conduct the meeting. Say, so what is the minimum here now? Say if a company, in case of public limited, let's talk about a public company. If it's a public company, the if 1,000 members attended the meeting, then minimum 5. If a company has more than 1,000 members, minimum 5 members are supposed to attend. The company has above 1,000 and up to 5,000 members, then at least 15 members are supposed to attend the meeting. If a company has more than 5,000 members, then at least 30 members are supposed to attend the meeting. Present the meeting. Attending the sense present the meeting. Okay. So that minimum, depending on the number of members a company has, the minimum number of members should attend and present the meeting to conduct the meeting. Okay. So if it is a private company, minimum 2 members personally must present at the meeting. Do you have any doubts here? I'm saying to conduct a meeting, minimum number of members to be attended. If these minimum number of members are attended, present at the meeting, then only a meeting will be held and the issues relating to the meeting will be discussed. If not, do you got any doubt what to do? No doubt. If quorum is not present within a half an hour of the time of meeting, then a meeting stands adjourned for the same day in the next week at the same time and place. So for example, today 10 o'clock meeting set. till 10:30 no directors, minimum quorum has not joined. Then it's implied meeting will be adjourned, in the sense postponed to the next week. Same, today is what, Saturday, so next Saturday, see, that is, what is next Saturday date? 5th March, Saturday, 10 o'clock, the same place, whatever place today meeting said, the same place they will join again, attend for the meeting. Okay. If any, if it is not possible on the same day, on the same place, or any other engagements are there with that same stance, then they will shift to other time and place, but according to the board decision. Sometimes the meeting itself will be cancelled. If quorum is not attended, means meeting itself will be cancelled also, postponed or cancelled. Okay. If even for the adjourned meeting, still no doubts you are getting. So next meeting also, if no one is attended, then again appointed for holding. Whoever members are present, that itself is taken as the quorum. Whatever the number of members attended, that itself is taken as the quorum. The meeting will be conducted. Only one postpone will be takes place. Now, the next prerequisite of meeting is chairman of the meeting. Chairman of the meeting is, who is the chairman? A person who is designated or elected by the members of the meeting in order to conduct the meeting or proceedings of the meeting is called as a chairman. Generally in assembly we see a speaker. Same here in the meeting, a person who conducts and undertakes the proceedings of meeting during the meeting is said to be a chairman. Okay, generally how does chairman will be appointed? The members elect one of their member as a chairman. Okay, whoever the members are there, among those members only one of the person they'll elect as a chairman. This election by voting or by show of hands. By show of hands, they will elect. Okay, the chairman. And voting rights depending on the number of shares held by the shareholders. Why do they elect the chairman? Why specifically? Board of directors are there now. Why again? So let us see the functions. The chairman, member, the elected member of the shareholders, who is acting as a chairman, performs certain functions. Like he is the person who is responsible to see meeting is conducted properly, conducted and constituted. And he must ensure the proceedings of the meeting are conducted according to the rules, and the order and the decorum is the discipline is followed. That's the reason why I'll not allow chat. Just to say hi, hello. Please don't use the chat box. So the main function of the chairman is to see that the meeting is conducted properly, conducted and constituted, and he's also responsible to see that the proceedings of the meeting, whatever the protocol or whatever the procedures are, that are conducted according to the rules and regulations of the Companies Act, and the required order and decorum is the at the meeting place, whatever decency and decorum is to be followed by the members are followed. Like arrangement, all the required necessary, providing all the important documents. Decorum in the sense, see if a meeting is relating to the appointment of a particular director or secretary, then whatever the procedure has undertaken to appoint the director or the secretary, the related documents are to be provided to all the members attending the meeting. Without that any information, how can they take the decision? How can they appoint, right? So the related documents, like how do we appoint, what are the qualifications, who are the people eligible. Next, can adjourn a meeting. And chairman has the power, also he can adjourn the meeting if required, means among the members any disputes arises, any differences of opinions arises, then in such case, this chairman can adjourn the meeting also. Okay. We also make sure that all the directors required quorum attend the meeting. Okay, so just you might be seeing what is happening in the assembly and the parliament. Same right here also. Okay, can adjourn the meeting under such circumstances as and when meeting adopts a motion of adjournment. That means he can adjourn for half an hour, 1 hour, or the next date. All these functions are. This next one is proxy. The next requisite of meeting is proxy as per section 105 of Companies Act. Who is a proxy? Say for example, directors. Among the board of directors, one of the board of directors is the not in a position to attend the meeting. Then he has a right to appoint a person, an individual as a proxy to act on behalf of him. Okay, so a proxy. Okay, a proxy means who? A person who is appointed to present another and vote at the meeting on behalf of the another is called as a proxy. Means a person who appointed to represent a director or a member and vote at the meeting on behalf of such director or member we call as a proxy, an individual. So this through a documentation, this procedure takes place. So an instrument by which an individual is appointed as a proxy also important. That the document is also important. Any member of a company is entitled to attend the means who can appoint the proxy? Any member who has a right to take part in the meetings of the company, who has the right to vote. Any of that member can appoint a proxy. Okay? A member, not all. A member who has right to attend the meeting and the right to vote in the meeting can appoint a proxy, and this proxy can vote on behalf of this member. Okay. But proxy, who can be a proxy and what are the rules for appointing a proxy? First, there are certain rules. Who can, when can a proxy can be appointed? Who can be a proxy? And what are his rights? Relating that in Companies Act, there are certain rules given. So what are they? First one is a company not having share capital cannot appoint a proxy. If a company don't have the share capital, like they don't raise the share capital from the members, among the members, then they cannot they cannot appoint a proxy. Members only has to attend. A member of a private company cannot appoint more than one proxy to attend the same occasion. Yes, say for okay, company has share capital, but he want to appoint a proxy. Or we cannot attend the meeting, a particular meeting. So for that particular meeting, that member can appoint only one proxy. He cannot appoint more than one proxy. Next, third one. Central government may prescribe a class or classes of companies whose members should not be entitled to appoint another person as a proxy. Yes. Central government also has given certain instructions. Which members cannot appoint a proxy. Those members of that companies cannot appoint a person as a proxy. Say for example, X company, Mr. A director cannot appoint a proxy. Means that a director, Mr. A of X company cannot appoint a proxy if central government prescribes. Next, a person can act as a proxy on behalf of members not exceeding 50 and holding in aggregate not more than 10% share capital of the company carrying voting rights. There's a single person can act as a proxy for up to 50 members. A single person can act as a proxy on behalf of 50 members or 10% of the share capital of the company. Okay, the members' voting rights must not exceed 10%. Say, for example, I am only the director, I possess 10% of share capital of the company. So that person who is acting on behalf of me can be a proxy only to me because I hold 10% of share capital of the company. So he can act only for me as a proxy. If my share capital is below 10% and all the 50 members share capital is below 10%, then he can act as a proxy for all those 50 members. That is what that sentence means. A person, that is an individual, can act as a proxy for up to 50 members or aggregate of 10% of share capital. The proxy shall not have their right to speak at the meeting, entitled to vote only on a poll. He cannot speak in the meeting, but he can poll the voting. Okay? He has no right to speak in the meeting, but he can vote on behalf of the director or the person who he appointed. He has been appointed. Yes. A member of a public company may appoint more than one proxy. One proxy is in respect of certain shares and different proxies for other shares held by him. So, for example, like a public limited company can appoint more than one proxy. What we said, actually, a person cannot have one proxy, more than one, two, okay. But public limited company members can have more than one proxy, means he can have two proxies. One proxy for preferential shares, one proxy for equity shares. Like that, they can appoint. Okay, that is what. One proxy in respect of certain shares and different proxy for other shares held by him. Again, he should have voting rights. Right? Next, a proxy is not counted for want of quorum to conduct a meeting. A proxy can vote in the meetings of the company, but he is not counted as a quorum. Okay? So he is not counted as a quorum. He will not come under the quorum. The next prerequisite is, so who is proxy? A person who is appointed to represent a member to attend the meeting and vote at the meeting. Okay, any member of company entitled to attend and vote meeting of the company on behalf of the director or the member of the company. Next, a company can a company which has no share capital cannot appoint proxy, and a member private company cannot appoint more than one proxy to attend one meeting. Central government prescribed companies, prescribed directors cannot appoint proxy or will have a right only upon cannot appoint the proxy. A person can act as a proxy on behalf of 50 members or a person who is having maximum of 10% of share capital. A proxy have right to vote but no right to speak in the meeting. Public limited company members can appoint two proxies, but different proxies for different shares. Like equity shares, one proxy, preferential shares, other proxy. A proxy can attend meeting, vote in the meeting, but cannot speak and cannot hold a quorum, cannot be part of the quorum. Yes, that's about proxy. The next one is minutes. Minutes is a written record of the business, which is at the end of the meeting. This is right. So after the meeting, a written record of the business transacted at the meeting. So when a meeting is conducted, some decisions might have taken, right? Some decisions might have taken. So whatever decisions have been taken, whoever attended, the details of meeting, and then the members attended the meeting, points discussed at the meeting, and then decisions taken at the meeting. All these details are supposed to be provided in a book called a minutes book at the end of the meeting. So a written record of business transacted at a meeting is said to be a minutes. That is minutes book. A statutory obligation on every company to keep minutes of the proceedings of every general meeting of shareholders, board of directors, and creditors. Every company, irrespective of the type of meeting they conducted, must maintain the meeting proceedings, must record the proceedings of meeting in the minutes book. Whether it is a shareholders meeting, the board of directors meeting, or creditors meeting, or general meeting, extraordinary meeting, or resolution, whatever it is, whatever its nature of meeting, whatever, whosoever the meeting is conducted, but all the proceedings, whether the decisions taken or not, the proceedings of meeting are to be recorded in this book. Yes, and when to record the proceedings of meetings must be recorded in the minutes record within the 30 days of the meeting. From the date of meeting, within 30 days of the meeting, they should record these proceedings in the minutes, and they also should file with the registrar. If they fail to do, they will be punishable. Okay, and these meetings minutes book should kept open for reference of other members, those who are not attended the meeting, and it should be signed by the chairman of the meeting also, dated and signed by the chairman of the meeting. So that's about minutes book. Yes. The pages in the minutes to be numbered, and each page is to be signed and initiated at the last page of the record of proceedings, or each meeting shall be dated and signed by the chairman of the meeting. So you are supposed to remember, being a company law, when you are writing under company law subject, you are supposed to remember these requisites with the dates and the requirements. As I mentioned, this minutes book should be kept open at the registered office of company for inspection by members at least for 2 hours during the business hours of the company. Okay? And they should not charge any amount also. If the company failed to keep that, then it is fine up to 5,000. It will be fined up to 5,000, or sometimes a punishment also. Punishable with a fine which may extend up to 5,000. That's about prerequisites of company. I hope so you all understood. So what are the prerequisites of company? Prerequisites of company are proper convening authority. Only directors are eligible, or board of directors or national company law tribunal. The second requisite is notice. Third one is agenda. Fourth one is quorum. Fifth one is proxy. Sixth one is chairman of meeting. The seventh one is minutes. Okay, so total 7 requisites are there. In these 7, before meeting are notice and agenda. During a meeting, chairman, proxy, okay, chairman, proxy, and quorum. After the meeting, minutes. Understood? Yes. Now let us discuss about the types of meetings. Then how many different kinds of marked companies meetings? I'm sorry, this is kinds of meetings. So kinds of meetings are those, we have different types of, basically shareholder meeting, director meeting, special meetings, or under shareholder meetings, actually you have 3 types: statutory meeting, annual general meeting, extraordinary meeting. And directors meetings are 2 types: board meetings and committee meetings. Special meetings are relating to class meetings and creditors meetings. If we look into shareholders meetings, actually earlier statutory meeting used to be there for public limited company. Private limited companies no need to conduct any statutory meeting. Only public limited companies are supposed to conduct this statutory meeting also, along with its annual general meeting and extraordinary meeting. Statutory meeting means meeting which is required as per the special act or legislature. And only public limited companies generally conduct this statutory meeting immediately after commencement of business with regard within the first year. Okay, with regard to the details of company and the directors and all. That was there earlier. Now, as per New Companies Act 2013, new act, statutory meeting has been abolished. Means even public limited company is not required to conduct it. Okay. Earlier it was there, which is to be conducted only by the public limited company. For private company, it's not necessary. And this, when immediately after the commencement of business, they should conduct this statutory meeting with the shareholders and giving the details about the directors of the company and the auditors of the company, secretaries of the company, all these details to be informed to the shareholders in this meeting. But the new Act of Companies Act 2013 abolished this statutory meeting for public limited companies also. So we now shareholders meetings are only two: annual general meeting and extraordinary general meeting. So let us see about these meetings. Is the screen visible? Is this screen visible? See here, the same annual general, extraordinary, class meetings. These class meetings are brought up here. Members of meetings, important, yes. Yes. A company, in order to conduct annual general meeting, generally who can conduct? A public limited company, private limited company, which has share capital or which has no share capital, and also a one-person company must hold a meeting of its members every year. As this meeting is conducted every year, we call it as an annual general meeting. Okay, and let us see the important aspects of this annual general meeting. Uh, so here see the annual general meeting. Here we have annual general meeting, right? One second. Yeah. What are the important aspects of annual general meeting? Ordinary business. If generally in annual general meeting, routine business decisions will be taken. Okay, it's a meeting is very important for every company where based upon which the business further active business actions are taken upon. Routine business related decisions are taken in the annual general meeting of a company. Okay. So let us see what are the ordinary business topics discussed in the annual general meeting of a company. Okay. First, consideration of annual accounts of company, for declaration of dividends, for the appointment of directors or appointment of auditors, or to fix their remuneration. For any of these 15 business matters, they'll conduct these are the ordinary business matters to transact these discuss upon. For the presentation of financial statements of companies, they'll conduct a annual general meeting. Okay, and if they want to any other matters, special purpose matters or any special business matters to be discussed in the annual general meeting, then it plays an important role to the shareholders, because this is only the meeting where shareholders join and discuss about their affairs of the company. And so those important decisions in the annual general meeting can also be taken, but by passing the resolution. About resolutions, we discuss in our next class. Okay, so to conduct this annual general meeting, what are the legal provisions required? First, a company must conduct this annual general meeting within 9 months of its financial closure of the financial year. Say, for example, 31st March to 21 financial year, they close the books. So within 9 months, means by March 22, December 22, 21, they should conduct the business. Okay. Yes. So, I'm sorry. So within 9 months of the closure of their first financial year, closure of the financial year, they're supposed to conduct the meeting. Okay, and means annual general meeting. For first annual general meeting, they'll get a 9 months time. For the remaining annual meetings, they'll get a like 6 months only. So 31st March, they closed the books. So first annual general meeting till December 21, they have the chance to conduct the meeting. Once if a existing company that is succeeding annual general meetings, whatever are there, that they are supposed to conduct within 6 months. That means by September 21, they are supposed to conduct their annual general meeting. Okay, 31st March books are closed with, by September 30, they're supposed to conduct the annual general meeting. So first meeting, they have nine months time from the closure of financial statements. Succeeding meeting, annual general meetings, they have 6 months time only to, after the closure of the financial statements. The gap between two annual general meetings must not be less than 3 months. And it should not exceed the 3 months also. Okay. Sorry, extend time 3 months and not more than 18 months. The gap between, I'll take the highlighter. Highlighter is there. So this one. So first meeting is within 9 months of the date of closure of financial year. Okay, it's not coming. Subsequent means within 6 months from the date of closing of financial year. Gap between the AGM should not be more than 15 months. Okay, up to 3 months they can exceed. And the gap between two successive AGMs should not be 18 months, not exceed 18 months. Okay, and further that no calendar year shall pass without an annual general meeting. And without annual general meeting, they should not pass the calendar year. Okay, no calendar year shall pass without annual general meeting. These are the legal provisions for conducting annual general meeting. And the next one is proper authority. Proper authority is the who can conduct. As we have seen, the board of directors can conduct. Okay. So this board of directors can conduct the meeting only. As we have seen that who can convene the meeting? Board of directors or central government tribunal, right? So obviously even AGM also board of directors only to conduct the meeting. Right. Next one is notice. When a notice to be given, 21 days must be given. 21 days before notice to all the members entitled must be given. 21 days notice along with an agenda must be given to all the members entitled to attend the eligible to attend. Entitled, if you don't have, eligible to attend the meeting must be given. Okay. And in us, see, every meeting you can write this notice under the notice, whatever you learned, that same points you can write under every notice. Means every meeting. A notice is compulsory 21 days before notice, and notice must contain date, day, place, time. Okay. And this notice must be sent to all the eligible members, and a copy of director's report, audited annual reports also has to be attached. The next, if they fail to conduct, and by default they are holding yes, the company not conducted any meeting, then yes, default. So if default is made in holding AGM, then the national company tribunal will send the application. At least then they should call for the conducting a meeting. Penalty, if they don't conduct, they will be fined up to 5,000 per day. First is 1 lakh. If they still not conducting, per day 5,000. Okay. The next one is extraordinary general meeting. Extraordinary general meeting means a meeting which is conducted between two annual meetings. We called as extraordinary general meeting. A meeting which is conducted between two annual general meetings. Okay. That is other than annual general meeting. It's called as extraordinary meeting. Convened, decided one. So this meeting is conducted to discuss the important business decisions, in order to take the important business decisions, and which cannot be keep aside till the annual general meeting. Decisions which cannot be kept pending till the next annual general meeting. All those meetings, all those decisions are taken with the extraordinary general meeting, by conducting extraordinary general meeting. Okay. And this, say for example, like if they want to change an objects clause, or if they want to change the registered office, under the incorporation of a company, important documents and alteration of memorandum we learned. So whatever the alteration of memorandum required, whatever the clause is required in alteration in memorandum, or any of such clause decisions, alterations in the memorandum will be conducted by extraordinary general meetings if immediately required. Now, who can conduct the extraordinary general meeting? Board of directors can conduct the extraordinary meeting. Board of directors, okay, can conduct extraordinary general meeting, and they are supposed to, and these must be in India only. Within the, they can be held at any time within the India only. Okay. And notice, 21 days notice before holding the AGM must be, extraordinary meeting must be given. Okay. Amended to vote, give their consent. After that, must the members who are eligible to give their vote must give their consent to attend the meeting. How many? 95% of the members should give their consent to attend the meeting. Then only they can conduct extraordinary general meeting. Yes. Directors, quorum. That is the quorum required. Is 10% of the total powers, 10% of the paid-up capital of the company members who are having can attend. And quorum required to conduct the extraordinary general meeting is 5 in case of public company, 2 in case of private company, 1 in case of one-person company. Yes. And in this again, and who else? The tribunal can ask the company to conduct the extraordinary general meeting on its own motion, or application of directors, or an application of any member of the company. In any of these three situations, a tribunal can also hold the extraordinary general meeting. There is a case given here. Parsi Dant and Rafiq Ahmed, the two directors in a company, and there is a serious dispute between these two of them. So they want to, because of which the entire management has become deadlocked, means has become like ineffective, and the functions has become functioning of the organization become difficult. So company and they are not attending the meeting also. They are not conducting any extraordinary meeting also. Then court has taken interruption, means involved and involved and conducted this meeting to solve the issue between these people. Okay. The company failed to is officer in default. If a company failed to conduct this extraordinary meeting for such important decisions, the officer in default who is responsible will be fined up to 1 lakh or 5,000 per month per day. The next one is class meetings. We'll stop with this. Class meetings. Class meetings means generally company has different types of shares, right? Like equity shares, preferential shares. Again, under preferential shares, different types of shares. So, in such case also, company will conduct these separate meetings for different classes of shareholders. And because the shareholders in these meetings, the shareholders' rights, depending on the rights and the right to vote, these meetings differs from shareholders to shareholders. That's the reason why it conducts different meetings for different classes of shareholders whose rights are affected. Okay, and company also pass certain resolutions binding only on the members with respect to classes of shares. So that's about meetings of companies, under which we learned shareholders meetings, annual meeting, annual general meeting, and extraordinary general meeting, class meetings. Okay, in our next class we'll discuss about meetings of board of directors and credit special meetings. After that, resolutions. Thank you for being here. Right. And stop sharing here. Do you have any doubts? You can raise your doubts. You can unmute yourself. You can unmute yourself. Yes. Do you have any doubts in today's class? You can unmute. Shahjahan Begum, you asked me that I'm not giving you the chance to speak. Yes, you can unmute your mic and you can speak. So I feel that no one has any doubts. Shahjahan Begum, are you there? Not unmute. I have permitted, ma'am. Try to unmute yourself. Try again. Time up. Again, university will end the session.
Okay, ma'am. Thank you.
Yes. So you don't have any doubts?
No, ma'am, not having doubts.
Right, right. Thank you. So you understood today's topic?
Yes, ma'am.
Yes, ma'am.
Thank you. We'll meet tomorrow, same time.
Okay, ma'am.
Okay, ma'am. Thank you.
Thank you.
Thank you, ma'am.